People often wonder, how does drug use affect criminal charges? Drugs, alcohol, and crime often go hand in hand. Some people think that they can't be charged with a crime if they were drunk or high. Some people think being drunk or high should be a crime in and of itself. But how do the two really interact? How does drug use or substance abuse affect criminal charges? There are really two ways. One is as a defense to a charge, and the second is as a mitigation factor in sentencing. Starting with the defenses. Firstly, you should understand that substance abuse, intoxication, is rarely, if ever, a defense to a criminal charge. Involuntary intoxication, where you are not responsible for the intoxication, meaning somebody drugged you or you accidentally became intoxicated, can be a defense to charges, but it's very unusual. Voluntary intoxication, where you are responsible for your own intoxication, whether you intended to be intoxicated or not, can be a defense to an element, the mental element of a crime. Meaning, if intent is an element of the crime, voluntary intoxication can negate that element. For example, if someone is charged with premeditated murder, which requires the intent to commit murder, if you can show that you were intoxicated of your own volition, that can negate the intent element, and you may be able to resolve the case to a lesser charge such as manslaughter that does not require the intent element of a crime. Again, this is a very difficult thing to prove and a very difficult thing to get through a jury. Common examples of using substance abuse in mitigation would be, for instance, if you committed a theft in order to get money to get high. That would not be a defense to the charge, but it would be an explanation of the behavior. A judge can consider that in deciding on your sentence. For instance, whereas you may be facing prison time for the conviction, if the judge believes that your substance abuse drove the crime, he can sentence you to probation conditioned on drug counseling instead of the prison time. That's called mitigating, a mitigating factor. Of course, you should understand that the mitigation is not automatic. You must prove this to the judge. You must present evidence and documentation to show why you deserve that mitigating circumstance. That's why having a lawyer from the beginning of the process to the end of the process is important. This is something that I do all the time, and we know how to present it to a judge to help you get the best sentence possible. If you are charged with a crime and you have a substance abuse problem, give me a call to discuss how the two can interact and what we can do to help you resolve your case in the best way possible.